thank you so much for joining me today, Jamila Duncan-Bosu from the Anti-Trafficking and Labour Exploitation Unit, otherwise known as ATLEU.
That's right.
Thrilled to have you here. It's really interesting to meet you, especially at this time when we've got so much talk about the hostile environment policy and how that might impact on vulnerable victims of trafficking. So you're a solicitor with ATLEU,
That's right.
And you've been there since the start of the organisation. You've been litigating throughout that period of time, and you've been involved in some of the leading cases in this area. So I'm just really inspired to meet you today, and thanks so much for coming in. So I thought we'd start by just considering what ATLEU is. So can you tell me a bit more about what ATLEU is and what its mission, its purpose is?
So ATLEU is one of the first legal charities in the country to work specifically with victims of human trafficking and modern slavery. So in the main, I'm talking about men and women and children who are trafficked to the UK for the purposes of forced labour. So that could often be working in factories and building sites for little or no money, domestic servitude. So that's often in the main women who come to the UK for the offer of employment as a nanny or a housekeeper, and will find themselves submitted to a whole spectrum of treatment. So on one hand, it might be extremely long working hours for a very low salary. On the other hand, it could be severe abuses. So I've had clients who've been subjected to very severe physical and sexual assaults.
What are the main principles that guide your work in ATLEU?
So ATLEU's aim is essentially to assist victims of trafficking and modern slavery to obtain safety, recovery and redress. So when I say safety, it's about getting victims into a safe place. So that could be regularising their housing situation and their immigration status. Recovery, that's giving them space and time to recover from their position, from their treatment. So again, that may be regularising their immigration status, signposting them into the correct services so they can get the treatment and support that they need. And then finally, redress. So that's about getting them compensation for the wrongs that they've suffered. So for lots of victims, this can be life-changing sums of money. So for example, I've recently acted for somebody who was in domestic servitude for a period of 9 years. So during that 9-year period, she was expected to work extremely long hours, her movements were severely restricted, she was subjected to kind of very severe verbal and physical abuse. So she was able to recover the national minimum wage for 9 years of mistreatment, as well as compensation for some of that injury to her feelings. With that sum of money, she was able to pay for her children's education. She was able to pay for her husband's medical care, and those have been the push factors. They were the reasons that she left her family abroad to take employment in the UK. So being able to obtain compensation was life-changing, life-altering in the sense that she could educate her children and they were able to break that cycle of exploitation. Her daughter then didn't accept work as a domestic worker and leave her home country. So I can't emphasise enough just how important being able to obtain compensation and redress actually is for victims. So most of our clients are referred to us by trafficking support providers. So for example, the Salvation Army has a contract to house and support victims of trafficking. So often we'll get referrals directly from some of those support providers. We work with other charities who assist victims of trafficking. So for example, in the north of England, there's a charity called Hope for Justice. So we work quite closely with them. They will often contact us about clients who need support around their housing, immigration or compensation claims. Unfortunately, the sad thing is there is no shortage of victims of trafficking and modern slavery. We are one very small organisation in London. At the moment, I have clients who are in Manchester, Durham. You know, we have a national presence, and that in part has been because this has been a newly developing area of law. For example, in the area of compensation claims, there was difficulty because of changes in legal aid. Employment law was taken out of scope. So naturally, a lot of the work around trafficking compensation claims was done by employment caseworkers. So majority of law centres across the country pre-2012 had somebody who was very experienced and knowledgeable around employment law and compensation issues. LASPO changed that. Employment was taken out of scope, so lots of law centres let their employment caseworkers go. So there have been some recent changes in that the Legal Aid Agency have made legal aid available for trafficking compensation claims, which means that law centres or any legal aid provider can now bid matter starts to bring trafficking compensation claims. there is a huge demand actually for compensation claims to be brought. There are many different ways in which a compensation claim can be brought. There are victims who are able to bring claims against their trafficker, either because their trafficker is identifiable, their trafficker has assets, and most importantly, the victim feels strong enough to be able to face them in a court or tribunal. There are other victims of trafficking who, for example, are particularly traumatised, particularly vulnerable, and aren't in a position to face their trafficker in the courts. Unfortunately, in lots of cases, there is a failure to identify or a failure to investigate or take the appropriate steps. So we feel very strongly at ATLEU that in those situations that we should still take steps to hold public authorities to account, because that's the only way that provision and treatment for victims of trafficking and modern slavery gets better. The reality is each and every victim of trafficking has some potential avenue for a compensation claim, whether that's directly against their trafficker or a claim against the state or to the states in the form of a criminal injuries compensation claim.
How do you help somebody go on a journey from that climate of fear to feeling able to confront their trafficker or exploiter in the courtroom?
Well, absolutely, it's not a quick process. Most of the clients that I work with have come from countries which don't really have the concept of the rule of law. They're countries where how can I put this, you may not have the same faith in the police as you might over here. Or to put it bluntly, they're countries where the police and the judiciary can be bribed. So the first thing that most clients will say to me is, don't be ridiculous, I don't have money. I'm not going to fare very well in this system. So actually it's a very long and often slow process of just breaking down the UK legal system to victims and explaining how it works and where they fit in that system, and actually supporting them all the way through it. So I have lots and lots of clients who will say, I'm scared about going to the police. And the reality is, in the UK system, you're a witness for the prosecution, you don't have your own lawyers, you don't play the same part in the system. So that's why for many victims of trafficking, a compensation claim is a way of them having some agency. There isn't anything that happens that they don't know about. They're the ones who give the instructions, they're the one that's in the driving seat. So often they can have more confidence around the compensation process just because they can have more involvement in it. Having then been through that process, it can give many victims the confidence to then approach the police. And you can then do that sort of measured approach to the police. So I have some victims who have got very good support providers around them. So if they are willing to speak to the police at the outset but are scared about what might happen, then a sort of soft meeting can be set up. So I've had clients who've been introduced to a police officer who then talk through what's going to happen, what their role in the process will be. But as a compensation lawyer, I suppose I'd always say that being able to bring that compensation claim and that being the first introduction perhaps to litigation and proceedings may be the thing that gives them more confidence to pursue a criminal claim. And again, it's things like for example, I've had a victim of trafficking who had been extremely unwell and hadn't wanted to go to the doctor. Again, she'd heard through the press and through others that potentially she could be arrested because she was illegal. We were actually able to give her some advice about her immigration status, what being recognised as a victim of trafficking actually meant for her, and actually reassure her that there would be no repercussions if she were to enter into services such as going to the GP, trying to get into education, all of those kinds of things. So actually it's just about being very clear about what trafficking status actually means for that individual.
In your experience, how well suited is the English legal system at the moment to actually achieving some redress for your client group?
So I have managed to bring claims for victims of trafficking in the employment tribunals, county court and high courts. And that's using various parts of domestic legislation. So for example, in the employment tribunal, we might bring an unlawful deduction of wages claim. We might bring unfair dismissal and wrongful dismissal complaints. Depending on the nature of the treatment, we might also bring discrimination complaints. So for example, I acted for one victim of trafficking whose employer insisted that she wore a hijab even though she was Christian. So we were able to bring religious discrimination complaints. Depending on the sort of comments made to victims and treatment suffered, then it may be possible to bring a race or a sex discrimination complaints. Similarly, for some victims of trafficking, for example, those who have been trafficked into sex work, the employment tribunal wouldn't be the appropriate forum. You would be looking at bringing tortious complaints. So it might be sort of false imprisonment complaints, personal injury complaints. But in essence, what you're trying to do is break the treatment down to its component parts and find a label for it. What would be a far better position is if we could rely on a civil remedy, so if there was a tort of trafficking. So in the same way as in the Modern Slavery Act has a criminal offence of trafficking, there was a criminal offence of trafficking someone into domestic servitude, there should be mirroring civil remedies so that somebody can go to a court or tribunal and say, I'm a victim of trafficking, and that in itself is a cause of action leading to a certain remedy. A tort of trafficking would then also encompass something around time limits. Almost each and every client that I bring a claim for is in some way late, either to the tribunal or the High Court. Often it's because they've been within that trafficking situation for a very, very long time. So they could have been there for 10, 15 years, and then they're looking at sort of 6 years for a breach of contract complaints. Often you're having to bring arguments around limitation and knowledge, and when it was genuinely possible for a victim to bring a claim. And that in itself can make proceedings longer, and then that in itself can make things more difficult or traumatic for a client. So having a civil remedy with very clear elements of the civil wrong, something very clear around time limits, and something very clear around remedies. Often we're having to argue that the loss of an education should be covered under special damages, for example. Again, if we had a very clear civil remedy, all of the types of things that we know happen to victims, the harms that we want to deal with and the redress that we want to put in place could be covered within the civil remedy.
So that covers the domestic legal framework. What about international law and the impact or potential impact of the UK leaving the European Union, given that at least some of the anti-trafficking legal framework is derived from EU legal instruments?
So I think it really does remain to be seen what the effects of Brexit will actually be for this particular client group. A lot of the protections for victims of trafficking are set out in the directive and the convention, so we'll remain members of the Council of Europe Convention. In my view, actually, the strongest protections are those which we can approach via Article 4. So again, hopefully that's something that we would still be able to rely on. But I think the reality is we've got a government who've been very clear in saying that their intention and aim is to eradicate trafficking and modern slavery within the UK. So I'd be extremely surprised that a body of protections available for this particular client group at one point in time, I'd be very surprised, given the government's rhetoric, if they were to roll back on that. So I think my very strong feeling is that, that we should continue to bring these cases, continue to litigate and create that body of case law. If we then end up in a position where, post-Brexit, it's not clear as to what victims' rights are, we can then continue to lobby around the tort of trafficking and amendments to the Modern Slavery Act, but with reference to this body of case law that's been built up.
In your experience as a litigator in this area, what are some of the key emerging and developing trends that you're working on and seeing crop up?
Well, actually, I think because there are more cases now being brought to the courts and tribunals, there's more work to be done around how the court and tribunals make giving evidence possible for a victim of trafficking. So there's lots of work to be done around special measures, I think. So I think these principles are there anyway, but I think it's getting the tribunal to apply them to victims of trafficking and modern slavery. I think it's things like, for example, the limitation regulations. You've had the government, as I said, on one hand, are saying that they very much want protections for victims of trafficking and modern slavery, but on the other hand, they're tinkering with other bits of legislation and not thinking about how that impacts on victims of trafficking. A classic example of that is the limitation regulations, where minimum wage claims are essentially limited to 2 years. Very few of the victims that I see are fortunate enough to get in and out of their situation within a 2-year period. So we're looking at large potential losses for victims of trafficking if work can't be done around that, if cases aren't brought sort of challenging that position. There's work to be done around time limits and litigating around that. What is reasonable for a victim of trafficking? When is it reasonable for them to have to take action? Bearing in mind that within the national referral mechanism there's a reflection period. It's accepted that victims of trafficking might take that little bit longer to disclose what's happened to them and to be able to give instructions, etc. So I think there's probably some work around that and some cases that can be brought around that.
Jamila, thank you so much for your time today. It's been fantastically informative and it's inspiring work again, so thank you.
No problem.